Thank you. And Mr. Garcia Rosenblum, if you wouldn't mind changing the name displayed on your Zoom, since we are using the transcription, I think it uses initials, so it'd be nice to make sure that um, your transcription displays your correct name.
Sure, just getting it up now. Sorry about that. All right, just changed.
Okay, thank you. That looks fine. So I'll begin the hearing as soon as I receive confirmation that we're live on YouTube. OTA, if you could please begin the live stream. Oh, and it looks like it started, so thank you. Good afternoon, everyone, and welcome to the Office of Tax Appeals, which is also known as OTA. We are opening the record in the appeal of Roxanne Villafuerte before the Office of Tax Appeals. This is OTA case number 230-914-240. Today is Wednesday, October 16th, 2024. The time is 1:03 p.m. We are holding this hearing electronically with the agreement of all the parties. My name is Lauren Katagihara. I'm the administrative law judge who will be hearing and deciding this case. I want to first clarify that this is an oral hearing before OTA, which is not a court, but instead an independent appeals body. OTA is staffed by tax experts and is independent of the state's tax agencies, including Respondent Franchise Tax Board, or FTB. As you are all aware, this hearing is being recorded and transcribed by Zoom. To ensure that we have an accurate record, we ask that everyone speak clearly and directly into your microphones. Please do not speak over each other or interrupt when someone else is speaking, and please provide clear verbal responses rather than nodding or shaking your head. If necessary, I may interrupt you to request clarification or ask that you speak louder, slower, or more clearly. Please also keep in mind that anything you say and anything visible through your camera can be heard and seen by the public. I'd like to begin by first asking the parties to identify themselves by stating their name for the record. Let's begin with appellant, Ms. Villafuerte.
Yes, good afternoon. Roxanne Villafuerte here.
And your representative, Ms. Villafuerte.
Edgar Irula should be here as well.
Mr. Rula, if you could unmute yourself and just quickly state your name.
Yes, apologies. My name is Edgar Irula.
Thank you. And who's here for Respondent FTB?
Yes, good afternoon. Noel Garcia Rosenblum for Respondent Franchise Tax Board.
And Brad Catino, also here for Respondent Franchise Tax Board.
Thank you. Just a couple of housekeeping matters. As we confirmed at the pre-hearing conference, the issue we are just considering today is whether appellant is entitled to the employer ride-sharing credit carryover claimed on her 2019 income tax return. Pursuant to the minutes and orders issued after the pre-hearing conference, appellant's exhibits 1 and respondent's exhibits A through F were admitted into evidence. The parties did not propose any additional exhibits. And respondent, will you please confirm that you are not presenting any witnesses today?
Yes, that is correct.
Thank you. Appellant, you identified Mr. Irula as a witness that will be testifying today. Respondent had no objections, so I'll swear Mr. Irula in now. Mr. Irula, if you would please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. We previously agreed that the time for today's hearing would be allocated as follows. Appellant will have 8 minutes to provide a presentation, an additional 5 minutes for Mr. Irula's testimony. Respondent will have 5 minutes to cross-examine Mr. Irula. Respondent will then have 15 minutes to provide a presentation, and appellant will be given an additional 2 minutes to provide a rebuttal and closing remarks. And if I have any questions for either party or Mr. Irula, I'll ask them throughout the presentation or afterwards. And with that, appellant, you may now proceed with your presentation and Mr. Irula's testimony, and you can do that in whichever order you wish.
Okay, thank you. Thank you also for the opportunity of letting me be heard today. We are here in dispute of the rideshare credit that was taken in my tax year 2019 and is currently being disallowed. The tax board explained that this credit is no longer available and expired back in 1986. That was the initial notice, or one of the notices I received in June 8th of 2023. Although this may be true, such information was not transparent either in the literature or in my tax preparer software. Such credits were displaying and available. Currently, I was informed by my tax preparer that this past tax year, the credits are no longer displaying or available to be taken. If this is a matter of the tax board not updating the servers adequately or some type of technical issue that for 30 years caused such credits to systematically and continuously be displayed on various tax softwares, I, as a taxpayer, feel that it should not be disallowed on my credits.
Ms. Villafuerte, did you want to have Mr. Urla testify at this time?
Yes.
Mr. Urla?
Yeah, so I just want to concur with what she was saying. I was informed that she was disallowed the credits, although you know, on my tax software, it was still showing up available. And with confirmation of other clients of mine, they also were issued such notice, although they didn't proceed to appeal the credit, but they were also informed by agents calling over the phone that apparently all the tax officers were still showing that credit as available. So, which is why I informed Ms. Villafuerte that although they may be correct that it's not, it expired already, I believe that, you know, she should still be entitled based on the lack of not being wasn't updated or anything on our end. Clearly to this past year filing, those credits are no longer displaying at all. So obviously it was something that needed to be done beforehand, but in her matter, I believe that she should at least be not disallowed for this year, for that particular year in count. And I think that's pretty much it.
Okay, thank you. So I just want to get clarification when you're saying that the credit is not being displayed on the tax software for this year. Do you mean for the 2023 tax year or?
Correct. I'm sorry. Yeah.
Okay.
Yeah. For past 2023, I'm pretty sure it's not displaying now, but for 2023, it wasn't showing it anymore. Although previous tax years, including 2019, which is in question and for Ms. Villafuerte, they all were displaying and available. Therefore, the taxes were still being processed with the credit and being allowed.
Okay, and you used tax software for the 2019 tax year?
Correct.
And just to get clarification, are you disputing, or it sounds like you're not disputing that you're not eligible for the credit, and it's just a matter of the fact that it was displayed as being available. Is that accurate, Ms. Villafuerte?
Is it not a rideshare credit like for people that use rideshare companies, correct?
It is a credit for you are claiming that it was an employer rideshare credit. And I don't want to get too much into it, but it's essentially that, give me 1 second. Sorry, it's a bit here. It's for certain years between 89 and 95 that allowed employers providing ride-sharing vehicles and subsidized public transit passes to have a credit for those expenses that were incurred.
Okay.
It's not just a matter of you using Lyft or Uber. You know, in the last few years, it had to have been you as an employer providing these rideshare vehicles between 89 and 95.
But I think her code for her rideshare is not the employer one, it's a code 171.
Is that for, so is the issue really the employee ride sharing credit? You had confirmed
It's
it was the
not.
employer.
The employer one, I believe, is trying to look on the actual tax form. I'm pretty sure. I don't know what exhibit you have it on there, but we're not disputing that the information that they gave was incorrect. But we're just we feel like she shouldn't be, I guess, charged that credit back. In other words,
Okay, so you're not
like she should be
disputing
allowed
that
at
you're
least to take it for
eligible
that
for the
particular
credit.
year.
You just believe sorry, let me say this again. So you're not disputing that you're actually eligible for the credit. You're just disputing that you should be entitled to the credit because it was shown as being displayed on the forms as being available.
Correct.
Okay, thank you. Okay, respondent, with that, you can proceed with your presentation. You have 15 minutes.
Thank you, and good afternoon. My name is Noel Garcia Rosenblum, and I, along with my co-counsel Bradley Catino, represent Respondent Franchise Tax Board in this matter. The issue at appeal is whether Respondent erred in disallowing the ride-sharing carryover credit claimed on the appellant's 2019 California tax return. Respondent received the appellant's 2019 tax return reporting an overpayment and corresponding refund in the amount of $1,942, which was issued to the appellant in March of 2020. Respondent subsequently reviewed the appellant's return and determined that the appellant improperly claimed the ride-sharing carryover credit in the amount of $912. Respondent issued a notice of proposed assessment informing the appellant that this credit had been disallowed and subsequently issued its notice of action affirming its assessment, in which the appellant timely appealed. In this appeal, the appellant does not contend that she is eligible for the ride-sharing carryover credit claimed on her return, but rather argues that she is entitled to this credit because the line for this credit is displayed and available on the respondent's tax forms, and she should not be at fault for out-of-date information. It is well settled that all credits are a matter of legislative grace, and taxpayers must prove that they meet the requirements for any claimed credits. Therefore, because the appellant has not provided evidence showing that she meets the requirements to claim the ride-sharing carryover credit, respondent's position should be sustained. Lastly, in regard to appellant's claim of being held at fault, respondent notes that its assessment does not impose any penalties or otherwise penalize the appellant for claiming this credit on her return. Instead, respondent's assessment simply corrects the appellant's return so that the correct amount of credits are reported. I'm happy to answer any questions you may have. Thank you.
Thank you. I don't have any questions for FTB, so appellant, you can proceed with your rebuttal and closing remarks. You have 2 minutes. Ms. Villafuerte, you're still on mute as well.
Sorry, one moment. Sorry about that. I'm going to ask my representative to take over at this moment.
Well, closing remarks will be the same. You know, we have no additional information that we want to provide, and everything is pretty much self-explanatory. And I believe that's just a standpoint that we have to see that if we could have it be allowed for that particular year.
Okay, thank you very much for your presentation. This will conclude the hearing. I want to thank everyone for their presentations today. This appeal will be decided based on the evidence and testimony presented. The record is now closed and the case will be submitted today. So we will send both parties a written decision no later than 100 days from today. This concludes the last hearing for today, and the Office of Tax Appeals will resume its hearings tomorrow at 9:30 a.m. You may now all exit the meeting. Thank you.